What would be like a couple of things that you see in some of the deals you've done that are like, hey, attorneys are going to catch this thing, but maybe the entrepreneur or the acquirer or searcher could like, I don't know, kind of like, oh, that's a red flag. Let me bring Darren in.
Yeah, so there's a couple things that I've thought of, and again, every deal is different, right? But some of the things that attorneys will think of that regular people don't, I shouldn't say regular, entrepreneurs don't, is, potential liability, meaning what's this company been doing? Are there any possible litigation, out there that's going to pop up his head? I mean, because the one thing that you really don't want to do is you don't want to buy a lawsuit, right? And many times that's because the person that you're buying it from is a little bit unhinged, or there's problems, or they're a serial litigator, whatever that is, right? Or the person you're buying it from has not been following corporate formalities, is doing some things that, might be a little bit shady, or, you're not all that comfortable with. And what you don't want to have happen is there's a skeleton that you didn't uncover, and then pretty soon you're subject to a lawsuit, right? And a good attorney will always have an indemnification clause when you buy the property, saying, hey, if I get sued for buying your property or for buying your business, you're going to indemnify my legal costs. But it's one thing to have a clause; it's another thing to enforce it. And
You got to chase them down, right? Like, who knows where they are now?
You got to chase them down, and then maybe they say, well, you know what, I'm not going to do it. Then what? Then you got to bring a lawsuit against him saying, hey, you need to indemnify me for this. And then maybe you win that lawsuit and you get a judgment against him. And then you got to collect. And that's its own problem, is collecting any judgment you get.
So that's really, really fascinating. So you've uncovered a few things there, Darren. When I also have approached deals, and all the deals I've done, it's all been asset purchases. So, I've just because of, with an asset purchase, you set up another LLC, or you set up your company, and you essentially just buy the assets of the other company that you want. They have their own company, so that if they did something shady 5 years ago, it's all on them. Is that kind of black and white pretty clear, or like, can that cross the barrier if somebody, just because you buy the assets doesn't mean you're protected, so to speak, from the previous company?
Yeah. So there's always, number one, anybody can bring a lawsuit, right? I mean, it's a great and terrible thing of the courts that we have today. But the other thing too is that there are so a little bit about my background, and we've talked about this, is that I'm really, what I do a lot of work on is bankruptcy work, corporate bankruptcies. I don't do very many individual bankruptcies, but a lot of corporate work. And within that, I deal with a lot of the sale and purchases of business through the bankruptcies. With that said, there are certain mechanisms or certain tools that people can use to try to claw back transactions that have been done, or even say, hey, there's a successor liability on this, meaning you, the purchaser liability, you, the purchaser, are liable for the acts of the parent company, because while you structured it so that it's just plucking the assets right out and putting it into a new company, the fact of the matter is the practical situation is that you purchased all the assets of the company, and all you really did is change the shell around it, meaning business A to business B, right? And there is some litigation tools that litigators can use to kind of get to that. With that said, it is expensive. It's difficult to prove. And again, that's why you want an attorney to kind of document this, so that you can kind of disclose certain things, or even have certain language in the purchase agreement to kind of protect you against these, to prove that it was a arm's length transaction.
Gotcha. That makes a lot of sense. Um, so ultimately, you just really want to make sure that you can trust the seller at all times, right? Because if there isn't, you can kind of pierce that corporate veil or whatever, and some of those lawsuits can follow the assets, right? You could find yourself in hot water down the road.
Well, and Ryan, I mean, you're right, but you're also, I also don't, again, I don't want to, I am not that attorney that looks at everything and says, boo-hoo, don't do this, right? But, but with that said, there's always the chance, right? And you don't ever want, entrepreneurs are very good at weighing risk, right? That's what they do. And so when you talk to a good attorney, or a good attorney will say, hey, here's some possible things that I'm looking at. Um, but the risk is pretty low. But as long as the client understands that there is that risk out there, right, then they can go for it. I mean, and the other thing too is as you know, as soon as something becomes extra risky, you can go back to the seller and say, hey, look, we need to renegotiate this price because I've had my attorney look at it, and at $100,000, the risk is too great. I don't want to do it. But hey, it's $60,000. I'm willing to take that risk. And so, it's just another avenue or another way to kind of weigh risk reward of purchasing that business or that asset.